in filing of this application, Your Lordship. Kindly see, Your Lordship, the pleading made in the missed case for condonation of delay, Your Lordship. Though the Megafed is the main party, Your Lordship, can you see?
Yes.
Lordship, kindly come to page. There is no paging, Your Lordship. Respondent, then Your Lordship, kindly petitioner most respectfully sued 4-5, Your Lordship, kindly.
You're referring to?
Lordship, in the missed case, Your Lordship, missed case.
This is application for condonation.
Application, Your Lordship, because the way in which the copy has been served to the state is really. Lordship, kindly to come to paragraph 5 of that misapplication.
5? There is no paragraph 5 here.
Lordship, in that missed case, Your Lordship, an application under section 5.
Yes, this is application under section 5.
Then, Lordship, I'm sorry to Lordship.
This is for prayer for condonation of delay.
Yes, Your Lordship.
Of 300 days.
Lordship, that means your
it has only
copy and my copy is.
It has only 3 paragraphs.
Your Lordship.
Any?
Then, Lordship, my copy and court copy is.
She can. I mean, the petitioner can issue fresh.
Lordship, I have 4-5. 4-5, Your Lordship.
Actually, that one was rejected. We had filed again, new one, sir.
Who was rejected?
By the registry. So we had done retyping.
Anyway, doesn't matter, Mr. Shulai. You can accept notice and then.
Yes.
Lordship, because Your Lordship, can you see in paragraph 3, Your Lordship? Paragraph 3, Your Lordship. In my application is paragraph 5. From court copy is paragraph 3. That the petitioner are senior citizen, unable to work for distance, also suffering from old age ailments, staying in far-flung areas, short of money, and undergoing treatment, Your Lordship. Where are the documents, Your Lordship, that you are suffering from this kind of ailment that you cannot travel? Lordship, can you see in the cause title, where is the resident of the petitioner? Care of Megafed, Shillong, Your Lordship.
Because they are staying Tura, one is staying Mokerwad, very far and very difficult for them.
There is one petition. There is one petitioner. Lordship, can you have in the cause title, Your Lordship?
Yes, only one petitioner.
One petitioner is Mokerwad, Your Lordship.
Yes.
It's a district headquarter of southeast or southwest.
But he was working in Megafed. Employee of Megafed.
And this kind of statement has been made on oath, Your Lordship. Lordship, I leave it to Your Lordship. This kind of statement, Your Lordship, the address showing something, and the statement is saying something, Your Lordship. I leave it to Your Lordship, because this statement has been made on oath, Your Lordship. It has been made on oath, Your Lordship. It is a solemn affirmation, Your Lordship.
Mokorwat has been given as the.
It's a district headquarter, Your Lordship. It's not far from Your Lordship. And then you say that I'm suffering from ailment, Your Lordship. Where are the documentary evidence to substantiate that?
That's a matter of argument. They are to substantiate their.
Your Lordship, there is nothing, Your Lordship. It's a three-piece paper application, Your Lordship. And Lordship, another aspect also, Your Lordship, it cannot be under Section 5 of the Limitation Act, Your Lordship, because the law of limitation is not applicable in proceeding, Your Lordship. She has to go by the rule of the Meghalaya High Court rule, Your Lordship. So this petition needs to be rejected, and she may be directed to file afresh, Your Lordship. Procedure has to be followed, Your Lordship. It cannot be under Section 5, Your Lordship.
Limitation is not applicable in the principle.
I'm sorry, I don't have the
principle. You see, the principle are.
This one only, sir, all along.
The principle are applicable, but not the letter.
Cannot be under Section 5, Your Lordship, because law of limitation is not applicable in proceeding.
There are there are opt-in decision to that in that regard, Mr. Shulai.
Law of limitation.
This court has more often, I mean, in more than one cases have dealt with such matter. Anyway, that's beside the point. We look at it when the matter is, heard. So, what is your submission, madam? Tell me.
So, Your Lordship, please allow these 4 persons to get their dues.
4 person. Where's the 4 person?
Abel
Only one is
Manga,
there.
Kathy D. Momin, Elias Catherine, Bhakti Bahadur, Raibak India, because they had retired. One Abel Manga is
We are
retired.
not into that. We are not into the facts. We are not into the merits. First, we are on this application for condonation. You have to satisfy
Only
the court.
condonation.
You take steps.
Okay, sir.
Lordship, you needs to supply a,
You give
proper
a
copy, Lordship.
give a proper
Okay, sir.
copy. Heard. Miss. Raman ne? S. Raman. They are counsel for the petitioner who has submitted that this application is for condonation of delay or filing a review petition in connection with writ WPC number 317 of 2008 since disposed of by this court. Though the respondent number 1, though the state respondent number 1 has entered appearance through the London AAG, Mr. N.D. Shulai. However, it appears that the copy of the application forwarded to the state respondent is not the correct or proper one. The petitioner is directed to supply the proper copy upon the state respondent. As far as respondent 2 and 3 are concerned, petitioner is directed to take steps for issue of notice upon the same. Notice within 2 weeks. This is matter thereafter.
Apply, Your Lordship.
Daily cost list, item number 1.
Lordship, I have matter in division bench, Your Lordship.
At least you could have informed me, request some of your colleague to. Yes, tell me.
Your Lordship, I have taken steps, Your Lordship.
No,
And
have,
it's still
so where were we?
But I had concluded my submissions, in fact, because the only issue here, my lord, is whether the maintainability of the petition. Now, a suit was filed, a money suit was filed. It was decreed, upheld by the appellate court. Review application was dismissed. Then on appeal before this court also, except for 27 lakhs, the trial court's judgment was upheld. And now they've come by way of 227 to challenge all those proceedings, the earlier proceedings. In fact, half the amount of the decretal amount also has been paid. Now, my friend on the last occasion has stated that he's sailing on a sinking ship. So I don't know today if he has anything to say.
My lord.
You've drop anchor.
Not yet, my lord. If my lord will give me some accommodation. My lord, the issue here is only one, my lord. Whether the powers of this court under 227 are merely supervisory or corrective also. Now, my lord, in all other cases, my lord, I would have bowed down to what the learned senior has to say, that at this stage I am precluded from assailing the proceeding under 227. But my lord, given the peculiar facts and circumstances of the case here, my lord, here there is a glaring example of my lord, non-exercise or wrong exercise of jurisdiction by the court at the stage of the trial, then at the stage of review, and as well as at the appellate level. But and so far as the second,
as far as I can, you see, with my limited knowledge, you're more knowledgeable than me, but exercise of power under 227 would be only to keep the subordinate courts and tribunal
within the bounds, within the bounds of their jurisdiction.
So
now,
if at all it is found out that they have crossed the limit or not acted up to the mark, well,
my lord, my submission here is that the trial court has erred in exercising the powers vested in it, my lord. It has given interest which is it has given compound interest which is not within its and there are other glaring inequalities.
You file an application before the trial court.
because you see now, yes, as has been submitted, have you assailed those order at the relevant relevant
My
point
lord,
of
what
time?
has happened is that whatever order has been obtained, my lord, these orders are all ex parte orders.
Party.
All ex parte orders, my lord.
Even
my lord, my lord, the end result is what has happened is that this has led to siphoning of, I mean, at the end of the day, it is wastage of public money, my lord. Public money has been siphoned,
Mr. Gautam,
my lord.
for all we know, it could be daylight robbery for that matter. But then, if it has been done, within the bounds of procedures and process,
and upheld by this court, my lord. That is the main thing. Upheld by this court. Now,
you
can
have
this
to-
court now?
you see, there's a lot of hurdles you have to overcome.
So, my lord,
This court would sympathize with you, But sympathy is not an element as far as judicial process is concerned.
My lord, I am also very sympathetic towards the public exchequer, which has to bear all this.
If they were, my lord, they should have contested the suit.
Unfortunately, my lord,
tell me,
litigants are of two types,
how-
my lord.
how
One is a
long-
living litigant
Yes,
and one is a.
why have you sought for accommodation now?
If my lord will just give me 2 weeks time, my lord, I will.
Again, this is a 2016 matter. It's been coming.
My lord,
on.
it
My lord,
has.
I have a suggestion to make. If at all they want, let us give our written submissions. Otherwise,
My lord,
this
I am
will keep
agreeable
on-
to that. I am agreeable to
See,
that, my
written
lord. I will give my written
submission-
submissions.
Written submission would come only after the oral submission because
Because I think in this matter it has already been heard.
he's
If he has some extra decisions to cite, let him come.
My lord,
in.
kindly give me 2 weeks time, my lord. That I will come up with decisions, my lord. Of course, I have submitted at the very outset, my lord. I am sailing on a sinking boat. One last accommodation, my lord, for to salvage my case. And of course, my lord, this matter is stacked along with another matter, my lord.
and who's
And the other counsel, Dr. Mozika, senior counsel, Mr. Mozika is here.
yes.
So he's
So, are you prepared to take up the matter?
Again, this is.
my lord, for me, one final chance, 2 weeks. My
Let
lord,
it
I
be
will.
positively.
No, no. See, I used to say, next time you come with a broken leg, what can I do? Seeing that I'm unable to speak. Once again, the letter counsel for the petitioner has sought for accommodation on grounds of personal difficulty. Learned senior counsel appearing for the respondent has the committee has duo not objecting to the said prayer, has however submitted that this matter being a long pending one, it would be prudent for the same to be expeditiously disposed of. The prayer made by the petitioner is allowed. However, the parties are requested to ensure that the hearing of this matter is taken up in due earnest. As prayed for, this is matter up to 2 weeks.
Oblige.
Item number 5.
Chief, because he was to obtain some instruction with regard to the constitution of tribunal as per the RTA Act or not, whether the state has constituted a tribunal or not. That is,
Why
That-
why would that take you so long?
that's why. Chief.
Why?
That is the
Either,
state.
you see, either you go to the website or you know, send somebody to the office and inquire. That should not take you long.
This is in fact the government asked time to obtain the instruction, Lord Chief.
Or it's for the government.
Yes, not me, Lord Chief.
Lordship, I'm appearing on behalf of my colleague Mr. KP Bharchaji. At this moment, Lordship, he is before the court number 1, Lordship. He's next before court number 1.
Then next week, then, Lord Chief.
It can be
In
taken up
the-
next week, Lordship.
Next week, in the meantime, he can have.
convey the message.
Mr. A.H. Karwala, additional senior GA, has submitted that the conducting counsel on behalf of the state respondent is indisposed and could not appear for this court today. Therefore, the instructions required to be confirmed before this court could not be produced today. It is prayed that this matter may be adjourned for the day. The counsel for the petitioner has no objection to the same. Accordingly, matter is adjourned. Please see after 1 week.
Highly obliged.
Item number 6.
Lordship, it is for me to file the written arguments. The written arguments are ready. I just have to photocopy to give the same to the state as well as the other respondents. I'll do in the course of the day.
Would you have you filed yours?
Yes, Your State is already.
And the counsel of the petitioner has submitted that the written argument in this case has been prepared but could not be filed. Could not be filed for this call. It is prayed that the same may be allowed to be filed in the course of the day. Pray aloud. This is matter.
Then this matter can be listed for judgment, Your Lordship.
First you have to file it.
Yes.
If I list it for judgment and you don't file, then what do I do?
Okay.
Because more often than not, you are the most elusive lawyer in this court. Every time we look for you, you are not to be found. This is matter Monday or Tuesday. So by the time I think the formalities would be complete, and you would have got a copy of the same.
I'll serve them copies, but I haven't received their copies. Let them
Give
serve.
them a copy, Your Lordship.
Please.
Yes.
Highly obliged.
Obliged, Lordship. Item number 7.
May I please, Your Lordship, my senior is on his legs on the other court, so I pray that this matter will be passed over for the day.
Oh,
This is regarding that.
yes, only for oral.
We have given written submissions.
Even from outside also we have given, Your Lordship.
So when do we do?
So I pray this matters may be passed over for the day, Your Lordship. After, let it come up after 2 weeks.
Why 2 weeks?
For the day, I thought tomorrow he meant.
1 week.
1 week.
On pay made by the petitioner, this is matter to 1 week.
For the day, I thought it was tomorrow. Pleasure.
Item number 8.
May it please Your Lordship. Lordship, senior counsel is on next. I pray for a short passover, Your Lordship.
End of the board.
Item number 9.
May it please your Lordship. Lordship, items 9 and 10 are connected matters, Lordship. I'm praying for some accommodation in this matter, Lordship.
What are these matters about?
This is regarding the forest colony land, Lordship.
The petitioner has sought for accommodation on the ground of personal difficulty. On payment, this is allowed. This is matter after 2 weeks.
They should have asked for adjournment in the morning, in the first hour, Your Lordship. I'm waiting here.
You see that I've made. You see, I keep repeating myself. Every time I sit in court, I've requested the counsel, if any mention is to be made, you do it immediately.
Yes, Your Lordship.
You don't have
I was
to.
sitting here
You don't have to
waiting
wait
this
for the
matter,
court
Your
to tell you. You can do it immediately. You rush to the bar and make your submission, but then once you
Very
don't,
unfortunate.
it's assumed that you are ready with the matter.
Lordship.
Not you, but then anyone for that matter.
To all, Your Lordship. Not partly to you, to all. Make
Please-
the mention
Please
in
keep
the
that
first
in mind.
hour.
Please keep that in mind.
Lordship.
Highly obliged, Your Lordship.
Obliged, Lordship.
9 and 10 would
To
be
9 and 10.
adjourned, Your Lordship, yes.
Item number 11.
Your Lordship,
Yes, Mr. Song, tell me.
I am seeking direction to the respondent number 2. The fact is that the BSF has taken the land of the petitioner in Chandu Bay. Then Government of India has released the fund also to the DC, respondent number 2, Your Lordship. Then till now it is
Yes,
not yet released.
who is appearing for respondent?
Okay, number 11. Nukme.
Oh, Nick, my lord. I missed this one, my lord. It is taken up on any other day.
Why?
Because it is a clear case, no order of stay, nothing. The land has been settled in favor of the petitioner.
My lord, as far as I know, there are some disputes, my lord.
No.
Between the private parties, 2 disputes, my lord.
Not private, it is third party. They have joined
My
and
lord, 2 parties have claimed for the same land, my lord.
No, the land acquisition proceeding is still
completed. Completed in favor of the petitioner, Your Lordship.
The money was not awarded because there was a dispute going on, my lord.
It was awarded and returned to the
No, you
DC
see,
already.
whatever the case may be,
My lord.
even if the money is not awarded, then there should have been a proceeding under Section 30 of the old act. I know this is the old or new act.
My lord. This kept my attention, my lord.
So,
My lord, another aspect, because there is another matter, if I'm not mistaken, my lord, which is filed by the same petitioner, my lord, which is also
That one, it is, Your Lordship, it is writ petition 314/2016. That is regarding road from Garobada to Ampati to Dalu, Your Lordship. So that is a separate matter, that is right of way only. But this is a land which has been taken by the BSF.
acquired by the BSF.
Acquired and money released to the respondent number 2.
That they will do. They are acquiring,
And when they are acquiring, they have correspondences with the petitioner, Your Lordship. Everything in the name of the petitioner. And somewhere between 2009-10, somebody third party has joined.
To my knowledge,
you see,
my lord,
even if somebody has joined, like I said, you see, if it is under the old act, then proceeding under Section 30 should follow.
No, in fact, my lord,
Your
there
Lordship.
was a dispute which was going on in the district council court, my lord, between the
It is
petitioner.
settled, Your Lordship,
and
in
the
2017 and 2018.
So, my lord, it went on for a long time.
Why you have not made them a party here?
Because at that time this was taken by some advocate. I have taken recently, Your Lordship. And
True. But then you see, you should have made them a party so that they will come and state their stand.
this matter has come to this honorable court only twice, Your Lordship, in 2013 and 2016. Their third party petition was not accepted in 2016 also, Your Lordship.
No, do you have any application for intervention?
They have gone to the district council and final order has been ordered by the CM and concurrently given order by the EM and CM.
All those facts related to the case has to be brought,
In fact, I have stated in my rejoinder, Your Lordship.
Oh, you've stated your
Yes.
fine.
Lord,
Rejoinder I have given to them also.
Lord, rejoinder, my lord, perhaps the same ought to have been included in the repetition.
Anyway,
already I have filed a
if those are-
rejoinder to their
if that is
affidavit.
if that is the result of subsequent events,
The problem is, my lord, what happens is that when we file affidavit, my lord, we file it on the basis of the documents which are there in the writ petition. Now, what happens, my lord, when a rejoinder is filed and a new documents are brought in, my lord, then it becomes difficult for us.
it should be.
Because our, my lord, our submissions and averments are based on what is stated in the writ petition. That is the point.
But according to this,
can-
Your Lordship,
Just
the
see, for
petition is very clear.
For academic purposes,
Yes.
in a rejoinder, can new pleadings or facts can be introduced, or you rejoin or react it to the
We
counter
have-
affidavit?
Your Lordship, we have filed rejoinder on the basis of to the point raised by the
Yes.
respondent only.
Exactly. That is the purpose of rejoinder.
Yes.
But if new facts, if Mr.
No,
Bhattacharjee is
no new fact.
correct, then if new facts are brought, then it's a different thing.
Nothing, Your Lordship.
So I'll also check it up, my lord, because
And you check the aspect of the, see if there's another party involved, then if any order is passed by this court, it would be seen as an ex parte over other against, a third party or anybody who may equally have a right.
did the opposite party?
No.
Or they've never filed?
Opposite party, they have not filed this thing. It may be mentioned, Your Lordship, there is another case filed by the third party, WPC 393, 2018. That is in another bench, Your Lordship.
Same subject matter?
Not subject matter. They are agitating the order of the EM and CM.
Yes.
Only
that's what I wanted to,
My lord,
Yes,
the dispute still continues, my lord, if that is so.
That
the
case
dispute
is coming
continues.
on the third, Your Lordship.
That means that matter is still undecided.
Yes.
But in that one, my stand also, Your Lordship, the concurrent finding of the executing officer and the appellate authority already. And
Mr. Sangma, what happened is, if that is the case, you see, of course now you're being fair. If that, you see, I don't know what's the subject matter of that case, but if it pertains to the dispute raised in this petition, and that matter is yet to be decided, if this is decided and perchance you are getting the relief, direction is given to hand over the money to you,
Correct.
and any order passed in the other court,
Petitioner succeeds, then it will become a problem.
then you can.
that is coming on the third, Your Lordship.
So lord, that matter will have to be settled first.
In fact, these kind of matters, the case should be tagged together, heard together.
Yes, Your Lordship. But it has come to the different bench.
Because, my lord, division bench?
No,
Or different
single
bench?
bench.
So, my lord, because my respectful submission, my lord, because that dispute needs to be put to end, my lord.
Yes, of course.
That has to attain finality, then this can be taken into
Because
consideration.
see, Mr. Sama, what happens is if that dispute is settled and it goes in your favor,
My lord.
then there's no question for filing this. There'll be no issue here, because here you're
Then
also
this matter can be resolved thereafter.
here you're fighting your prayers for disbursement
Release only.
of the amount of compensation
Amount.
to you,
Yes, my lord. For the land acquisition.
which is also the subject matter in the other.
Correct.
You try to find out. You are also
In that, that also for them also I am appearing, Your Lordship.
okay.
The reason is that in that case also the third party has filed in 2016, and this honorable court at that time has not accepted their prayer.
2016.
2016.
This
Your
is a
Lordship.
2021
And,
matter.
yeah, before that they have filed but rejected. Their prayer was rejected in 2016.
Please,
Yes.
I'll not pass any order.
Yes.
But you just do your own homework, and then we'll see. On preliminary parties, let's this matter after 2 weeks.
Highly obliged, sir.
Item number 12.
Make a mention.
Yes, sir.
Yes, Mr. Paul.
Lords.
Lordship, the learned DSGI is on legs, Lordship. I pray for some more time, Lordship, for this matter.
This is our Union of India.
Against the Union of India, my lords.
Do we have an additional DSGI or an assistant DSGI?
I think, my lords, they are working a little short-staffed. I was, as a matter of fact, talking to the DSGI yesterday. The DSGI and, my lords, I think one CGC. All along, there was Mr. Debnath is there, my lords. All along, there was a panel. I think that there is no panel at the moment. So he's also finding it very difficult. With the number of litigation that the Union of India has, my lords,
If there's a number of courts, even in a small high court like this
Meghalaya,
one, with 2 or 3 courts functioning simultaneously, and if you have to be there in all the courts at the same time,
that becomes very difficult, my lord.
can we experiment with hologram?
We'd have to probably think of something like that, my lords.
Yes, so what do we do?
Have it after some other day, my lords.
How long?
Lordship, I pray if this matter can come up after 2 weeks.
On pre-made by the respondent, this is matter to 2 weeks.
That's
Highly opposed,
right.
Lordship.
Item number 15.
Criminal appeal.
Yes.
Lordship, I'm being led by Mr. Sengupta. He is on his legs in the other courtroom.
Well, lords, this is that matter where your lordships have on the last occasion, my lords, as a matter of fact, noted.
Yes.
No more.
I can begin, my lords. So I can just place the facts till Mr. Sengupta. I think if Mr. Sengupta is not taking too long.
Who is here? Only one.
Well, it's only the Deputy Commissioner.
Wait, Deputy Commissioner.
As regards, my lords, respondent number one has been, my lords, had deceased, and your lordships have struck.
Oh, that,
struck off. That same matter, my lords, where Mr. Sen was appearing. Let's hear the issue in a nutshell, my lords, even without getting into the merits of the matter is.
Yes. Please.
My lords, the issue here is, my lords, we are here before your lordships against the judgment and order passed by the Meghalaya Board of Revenue, my lords, dated the 17th of December 2014. The controversy, my lords, before I open the matter, my lords, I'll just give a brief backdrop. What is the matter all about? The controversy here, my lords, relates to a certain plot of land in the Relief and Rehabilitation Colony in Rinja, Shillong, my lords. Now, petitioner is the lessee in respect of that particular plot, my lords. The lease deed, in terms of a judgment and order passed by the then Honorable Guwahati High Court, has been in favor of the petitioner before your lordships. Now, the respondent number one, my lords, who is deceased, had at some point of time filed a complaint with the additional Deputy Commissioner. That complaint, my lords, was on the issue, my lords, of that the patta should have been.
Just a moment, Mr. Paul.
My lords.
Before we proceed,
Lords.
Why has the matter abated against the respondent, number one?
Well, it's because it was only a complaint. Against the complaint, my lords, there was an order passed by the Deputy Commissioner where no relief was granted to the petition to the respondent number one. There was only a referable as against me before the state government. To which extent, my lords, we went before the Revenue Board. Revenue Board, my lords, takes a view that there is no locus. I do not have locus to challenge that particular order. Which is why against that order, my lords, under 227, we are before your lordships. That because if, my lords, any ancillary relief would have percolated to the respondent number one, then the deceased would have to be substituted before lordships, but that was not done. And neither did they prefer any appeal against the order of the Deputy Commissioner, which did not grant them any relief. So as against that, my lords, the matter ends over there. So insofar as, my lords, her claim was that she was the owner of the property and she should have been given the patta. To that extent, my lords, the matter went before the Deputy Commissioner. We pointed out, my lords, that under the rules, Deputy Commissioner was not competent to hear that matter. It was only the Commissioner who's competent, my lords, to hear that particular matter. The Deputy Commissioner, my lords, by a very cryptic order, without really answering the issue, says that, my lords, we are deciding this matter only on a limited extent and we are referring the matter to the government for an appropriate decision in the matter. To that extent, my lords, we challenged the order before the learned Board of Revenue. The Board of Revenue, my lords, after recording the entire factual dispute that has happened between the parties, comes to a finding that I don't have locus to challenge that particular order. Your lordships would appreciate, it is my land which is sought to be, my lords, I am sought to be deprived from that land. If I don't have locus, who would have locus in the matter? That is the sum and substance of the matter before your lordships.
So the lease is in your name?
I am the lessee, my lords. That's the admitted position. I am the lessee. And the position of law, my lords, as I will place before your lordships, is that your lordships are aware that the proceedings before these revenue authorities are quasi-judicial in nature. So insofar as, my lords, if I am to be disentitled from any particular property, the remedy would have been to approach a civil court. It is only and only a civil court which has the power to pass an order of declaration saying that either you are competent or either you are in valid possession or you are in invalid possession. Revenue authorities would not be competent to do that.
You'll have to place before this court the,
well, I will take your lordships through the
contours of the
lordships,
jurisdiction of the quasi-judicial
lordships,
body, whatever.
I don't know if Mr. Sengupta is coming, well, I can begin, or else we can have it tomorrow subject to.
Yes, my lord, kindly have it tomorrow.
Not tomorrow. We'll have it on Wednesday.
Well, it's next week. I have a little difficulty, my lords. We could have it on 6th, my lords, subject to your lordship's convenience, or on
a Friday, because Friday sometimes we go.
5th, my lords, again, a lot of matters have been fixed, and 3rd and 4th, my lords, I have some personal difficulty.
So we'll have it on 9th.
9th. What we'll also try and do is, my lords, I'll have a small note prepared with advance copy to my learned friend to assist your lordships as to how this matter has travelled.
More often than not, you see those kind of notes or list of dates, all
we'll have a small list of dates prepared so your lordships can, my lords, while I'm taking your lordships through the annexures, your lordships will then appreciate what we say. And also the position of law as has emanated.
In view of the fact that the additional senior GA is indisposed, the matter is adjourned and on prayer made by the party. Matter is adjourned. Let's see him on 9th October.
All right.